On July 1st, 2026, the United States Department of Justice sued 2 states for banning your guns, not the NRA, not the Second Amendment Foundation, not the Firearms Policy Coalition. The federal government of the United States, through its own Civil Rights Division, walked into federal court and said that Virginia and California are violating the constitutional rights of their own residents by enforcing gun bans that cannot survive Second Amendment scrutiny. 2 lawsuits, same day, 2 different states, 2 different firearms, 2 different legal theories, and 1 legal tool that almost nobody covering this story has properly explained, because the statute the DOJ is using to bring these cases is not a gun law. It is a civil rights law. It was passed by Congress in 1994 in the aftermath of the Rodney King beating, and until 2025, it had never once been used to enforce the Second Amendment. That is the story. And by the end of this video, you are going to understand it at a level of precision that will change how you think about what the federal government's role in Second Amendment litigation actually is, and what it could become. Let me start with the legal mechanism, because everything else flows from it. The statute is 34 U.S.C. Section 12601. Congress passed it as part of the Violent Crime Control and Law Enforcement Act of 1994, the same piece of legislation that also enacted the original federal assault weapons ban. The historical context matters. The 1992 Los Angeles riots had just happened, following the acquittal of 4 LAPD officers in the beating of Rodney King. Congress wanted to give the federal government authority to intervene when local law enforcement agencies systematically violated citizens' constitutional rights. Here is what the statute actually says. It prohibits any governmental authority or its agents from engaging in a, and I am quoting the text directly, pattern or practice of conduct by law enforcement officers that deprives persons of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. When the Attorney General has reasonable cause to believe that a violation has occurred, the AG may file a civil action in federal court seeking appropriate, equitable, and declaratory relief to eliminate the pattern or practice. That is the statute. In plain English, if a police department is systematically violating people's constitutional rights as a matter of routine enforcement practice, the federal government can sue that department without waiting for an individual victim to bring their own case, and ask a federal court to permanently enjoin the unconstitutional conduct and require institutional reform. For 30 years, the Department of Justice used Section 12,601 fewer than 100 times, almost exclusively against police departments accused of excessive force, racial discrimination, unconstitutional searches, coerced confessions, and civil rights abuses. The LAPD, the Baltimore Police Department, the New Orleans Police Department, the Ferguson Police Department, these were the traditional targets. The pattern or practice was officer misconduct. The right being violated was typically the 4th Amendment, the 14th Amendment, or the Equal Protection Clause. Until December 2025, the Second Amendment had never appeared in a Section 12,601 case. Not once. In December 2025, the Trump administration established a new office inside the Civil Rights Division, the Second Amendment section. Its stated mission is to ensure that law-abiding American citizens may responsibly possess, carry, and use firearms, and to investigate law enforcement agencies that engage in a pattern or practice of infringing on law-abiding citizens' Second Amendment rights. The Second Amendment section's legal theory under Section 12601 is straightforward. Virginia state police officers are required by state law to enforce Senate Bill 749, Virginia's new assault firearms ban. SB 749 makes it a crime to sell, buy, import, or manufacture assault firearms, including AR-15 style rifles. When those officers routinely enforce that ban as a matter of daily law enforcement practice, which the DOJ argues is unconstitutional under the Second Amendment and Bruin, they are engaging in a pattern or practice of conduct that deprives Virginia residents of rights secured by the Constitution. Same theory in California, same statute, same legal mechanism. The critics are not wrong to note the novelty here. Denver City Attorney Miko Brown wrote directly to Assistant Attorney General Harmeet Dillon, Congress enacted Section 12,601 in the wake of the horrific Rodney King beating to provide the federal government with tools to combat excessive force and other kinds of misconduct in state and local police departments. Your effort to use Section 12,601 to mount a facial challenge to the city's democratically enacted ordinance flies in the face of text, history, and past practice. Colorado Attorney General Phil Weiser made the same argument. Virginia Attorney General Jay Jones's office called the Virginia lawsuit a misuse of the Civil Rights Division. Those objections have real legal weight. The courts will have to decide whether Section 12,601's pattern or practice language encompasses the enforcement of a democratically enacted state gun law, as opposed to the kind of systematic officer misconduct the statute was historically used to address. That question has not yet been answered by any circuit court of appeals. It is live litigation. But the statute's text is broad. Rights, privileges, or immunities secured or protected by the Constitution includes the Second Amendment. Enforcement of an unconstitutional law by law enforcement officers is, on the DOJ's reading, a pattern or practice of conduct that deprives people of those rights. Whether that reading holds is for the courts to determine. What is not in question is that the DOJ now has 7 active lawsuits under this theory in Virginia, California, Colorado, Denver, Washington, D.C., Los Angeles County, and the Virgin Islands. And Acting Attorney General Todd Blanche has signaled more are coming. 7 lawsuits, 7 months, since December 2025. Now let me take you through the 2 cases filed on July 1st. Because while they share the same legal vehicle, they are targeting very different laws, with very different constitutional arguments, in very different legal environments. The Virginia case first. Senate Bill 749 was signed by Governor Abigail Spanberger on June 16, 2026. Effective date, July 1st, 2026, the same day the DOJ sued to stop it. Here is what SB 749 actually does. It creates a Class 1 misdemeanor, the most serious misdemeanor classification under Virginia law, for any person who imports, sells, manufactures, purchases, or transfers any firearm classified as an assault firearm under the bill's definition. It also prohibits the sale of large-capacity ammunition feeding devices, defined as magazines capable of holding more than 15 rounds. The definition of assault firearm is feature-based and model-based. It covers semi-automatic centerfire rifles capable of accepting detachable magazines that also possess any one of a list of prohibited features: pistol grips, folding stocks, flash suppressors, barrel shrouds, threaded barrels. It also covers specific models by name. The criminal consequence for violation is significant. Anyone who willfully and intentionally sells an assault firearm to another person or purchases one from another person is guilty of a Class 1 misdemeanor. And conviction triggers a 3-year prohibition on purchasing, possessing, or transporting any firearm of any kind. That 3-year collateral disarmament is attached to what would otherwise be a misdemeanor. That is the penalty structure the DOJ is challenging. 2 things SB 749 does not do. It does not ban possession of previously owned assault firearms. If you owned a covered firearm before July 1st, 2026, you may keep it. The ban is on future commercial transactions, sales, purchases, imports, manufacture, and transfers, not on possession itself. Now here is what happened before SB 749 even took effect. And this is the compliance situation that every Virginia FFL needs to understand precisely. 2 Virginia Circuit Court judges issued injunctions blocking the ban days before July 1st, one in Lancaster County, one in Washington County. Those injunctions, however, did not apply statewide. They applied only to Virginia State Police and the specific localities named as defendants in those state court cases. Virginia Attorney General Jay Jones's office released a memo on July 1st clarifying that the injunctions did not cover the rest of the state. The result on July 1st, 2026, SB 749 was partially blocked in a small number of jurisdictions and fully in force in the rest of Virginia. Simultaneously, no statewide injunction existed in state court. No federal injunction existed in the DOJ's case. Virginia FFLs were operating under a compliance landscape that had no clear answer. The DOJ's lawsuit in the Eastern District of Virginia seeks a permanent injunction barring enforcement of SB 749 statewide. The Firearms Policy Coalition and 2 other Second Amendment organizations had already filed their own challenge to SB 749 on May 14th. Before the DOJ filed, there are now multiple pending legal challenges to SB 749 in federal court. None of them have produced a statewide injunction as of this video. The DOJ's legal argument in Virginia follows the Bruin framework directly. The Second Amendment protects not only the possession of firearms, but also the ability to acquire them through lawful purchase and sale. The right to keep and bear arms necessarily implies the right to acquire arms. A ban on commercial sales of a covered firearm is not a peripheral restriction on the exercise of the right. It is a direct restriction on the right itself. AR-15-style rifles are in common use by law-abiding Americans for lawful purposes. The DOJ's complaint cites the February 2025 figure, more than 30 million AR-15-style rifles in civilian hands in the United States. Under Heller's common use standard, that number places these rifles squarely inside the Second Amendment's protection at Step 1 of the Bruin analysis. Virginia then bears the burden of identifying a well-established historical tradition of banning arms in common use from the founding era. The DOJ's complaint states its position plainly. There is no historical tradition of banning arms in common use. The complaint also makes a rhetorical move worth noting for your audience. It directly cites Justice Clarence Thomas's dissent in Stenberg v. Carhart, a 2000 abortion case, for the proposition that the term assault weapons is a euphemism that gun control advocates use to gain support for banning modern semi-automatic firearms. The DOJ is embedding the Thomas framing directly into its own federal complaint. Now, and I want to be direct about this, because the Virginia case has a serious doctrinal obstacle that the DOJ is openly fighting. Virginia sits in the Fourth Circuit. The Fourth Circuit upheld Maryland's assault weapons ban in Bianchi v. Brown, 111 F.4 Teach 438, decided in 2024 in a 10-5 en banc decision. That ruling is binding precedent in every federal district court in the Fourth Circuit, including the Eastern District of Virginia. The DOJ's own complaint acknowledges this contrary precedent and asks the Eastern District Court to depart from it, or to hold the case in abeyance pending the Supreme Court's ruling in Viramontes v. Cook County, where cert was granted June 30, 2026. That is the realistic path for this lawsuit, not a quick district court win. The Eastern District of Virginia cannot simply ignore Fourth Circuit precedent. The realistic outcome is that the court holds the case pending Viramontes, waiting for the Supreme Court to answer the AR-15 constitutional question directly, and then applies whatever the Supreme Court says. If the Supreme Court rules in Viramontes that the AR-15 is constitutionally protected, Bianchi is effectively overruled, and United States v. Virginia wins by default. If the Supreme Court upholds assault weapons bans or carves out a narrow ruling that preserves state-level restrictions, United States v. Virginia likely fails even with the full weight of the DOJ behind it. The Virginia lawsuit may function primarily as a pressure mechanism, keeping the legal challenge active, building the factual record, and positioning the case to receive the Viramontes ruling the moment it comes down in June 2027. Now the California case, and this one has two entirely separate legal targets inside a single complaint, which makes it more complex and, in some ways, more significant than the Virginia lawsuit. United States v. California and Robert Bonta was filed July 1, 2026, in the United States District Court for the Central District of California. It names the state of California and Attorney General Rob Bonta in his official capacity. It challenges two distinct California schemes: Assembly Bill 1127, commonly called the Glock ban, and California's Unsafe Handgun Act, which controls what handguns may be sold through the state's handgun roster. Let me take them separately, because they are separate constitutional arguments. Assembly Bill 1127 was signed by Governor Gavin Newsom in October 2025. It took effect July 1, 2026. California is the first state in the country to enact this type of ban. What AB 1127 does, it prohibits licensed firearms dealers from selling, offering for sale, transferring, or delivering any semi-automatic machine gun convertible pistol. That term is specifically defined in the statute as any semi-automatic pistol with a cruciform trigger bar that can be readily converted into a machine gun by the installation of a pistol converter, what is commonly called a Glock switch or machine gun conversion device, without any additional engineering, machining, or modification of the pistol's trigger mechanism. The cruciform trigger bar is a design feature of Glock pistols and a wide range of similar striker-fired handguns. California is not targeting Glock specifically by name. It is targeting a design feature that California's legislature determined makes these pistols susceptible to illegal conversion with an aftermarket switch. Glock does not manufacture or endorse these switches. The switches themselves are illegal under federal law and prohibited in 29 states. California's theory is that because the pistol design enables easy illegal conversion, the pistol design itself can be banned from commercial sale. What AB 1127 does not do, it does not ban possession of existing Glock-style pistols. Pistols sold before January 1, 2026 are grandfathered. Private party transfers conducted through an FFL are exempt from the ban. The restriction applies to dealer sales and transfers, not to ownership of pistols already in circulation. New York, Maryland, and Connecticut have enacted similar Glock conversion bans. Every FFL and gun owner in those 3 states is watching this California litigation directly, because the constitutional question being litigated here will determine whether their state's ban survives as well. The DOJ's argument against AB 1127 makes an analogy the complaint frames carefully. A legal shotgun can be illegally shortened into a sawed-off shotgun. That does not give any state the authority to ban all legal shotguns on the theory that they could be converted into an illegal weapon. The mere fact that a legal firearm can be illegally modified does not remove that firearm from Second Amendment protection. California is banning the most widely owned handgun in the country, not because the handgun is itself a machine gun, but because criminals have used illegal aftermarket devices to convert it into one. The DOJ says that theory cannot survive Heller. California's counter-argument has already been filed. Attorney General Bonta's office filed its opposition to the DOJ's TRO motion, arguing that Glock-style pistols do not fall within the scope of the Second Amendment's plain text because they are machine gun convertible, and therefore fall outside Heller's protection entirely. That is an aggressive Step 1 Bruin argument. The pistol is not a protected arm at all, so the government's burden of historical tradition never even arises. The district court has not yet ruled on that argument. The second target in the California complaint is the handgun roster, and this is the part of the California lawsuit with the strongest near-term legal prospects because it runs directly into Heller's most explicit holding. California's handgun roster is a list of handgun models approved for sale in the state. To be added to the roster, a handgun must meet specific state-mandated safety features: a chamber load indicator showing the gun is loaded, a magazine disconnect mechanism preventing the firearm from firing when the magazine is removed, and, until recently, a micro-stamping requirement that would stamp the handgun's make, model, and serial number onto fired shell casings. The handgun roster was designed with those requirements in place. The result of those requirements, according to the DOJ's complaint, no new handguns were added to the California handgun roster between 2013 and 2023, a full decade. As older models drop off the roster because manufacturers make minor design updates, Californians are left with an increasingly limited and outdated pool of available handguns. Firearms that are often no longer manufactured, no longer supported, and no longer available anywhere else in the country. The DOJ's argument: the roster functions as a de facto handgun ban through attrition. The Heller decision, written by Justice Scalia in 2008, held explicitly that handgun bans are categorically off the table under the Second Amendment. A ban that operates through regulatory attrition rather than explicit prohibition is constitutionally indistinguishable from a ban that says, "You may not buy a handgun." The mechanism is different, the effect is identical. Acting Attorney General Todd Blanche put the handgun roster argument in the starkest terms possible. California cannot ban the most popular type of handgun in America. California's response: a spokesperson for Governor Newsom called the lawsuit politically motivated and stated that the state has data showing its gun laws have saved lives. Attorney General Bonta's office confirmed it would review the complaint and defend both AB 1127 and the handgun roster in court. Now let me give you the full picture of the Second Amendment section's campaign, because Virginia and California are not isolated decisions. They are lawsuits 6 and 7 in a 7-lawsuit campaign that began the day the Second Amendment section was established. In December 2025, the Civil Rights Division's Second Amendment section was founded. Its mission statement, published on the DOJ's own website, to investigate law enforcement agencies that engage in a pattern or practice of infringing on law-abiding citizens' Second Amendment rights, to seek litigation opportunities to secure those rights, and to advance a broad interpretation of the Second Amendment through statements of interest, motions to intervene, amicus briefs, and original lawsuits. What followed in the first 7 months: a challenge to Los Angeles County's permitting and enforcement practices restricting concealed carry, a challenge to gun permitting practices in the Virgin Islands. On May 5, 2026, a lawsuit against the city of Denver over its city-level assault weapons ordinance. The next morning, May 6th, a separate lawsuit against the state of Colorado over its statewide ban on magazines holding more than 15 rounds. On May 14, 2026, an amended complaint in the District of Columbia challenging DC's bans on AR-15 style rifles and suppressors, naming the District of Columbia, the Metropolitan Police Department, and Acting Police Chief Jeffrey Carroll as defendants. Then July 1st, Virginia and California. 7 lawsuits, 7 jurisdictions, all filed under 34 U.S.C. Section 12,601, all seeking permanent injunctions, all grounded in the same core Bruin argument. The covered firearms are in common use for lawful purposes, and there is no historical tradition supporting their prohibition. Blanche has stated publicly that more lawsuits are coming. Philadelphia is already under a DOJ investigation over its concealed carry permit revocation practices. The Second Amendment section's public mission statement describes itself as proactive in searching for litigation opportunities. This is a sustained enforcement campaign, not a one-time event. The Second Amendment Foundation's Director of Legal Research, Kostas Moros, described the DOJ's involvement precisely. It's great to have that giant 800-pound gorilla in the room with us, because courts, like it or not, do take the DOJ more seriously, and frankly, it's nice to have the DOJ at least seeing the Second Amendment as equal to all the other rights. The critics of the campaign are equally direct. Stanford law professor John Donahue said the Second Amendment section is unnecessary given the existing litigation infrastructure of gun rights groups, and that by pivoting the Civil Rights Division toward gun rights, the DOJ is walking away from its responsibilities to marginalized communities who have historically relied on Section 12,601 for protection against police misconduct. Those objections will follow every Section 12,601 gun rights case into court as amicus arguments from gun control organizations and civil rights groups who believe the statute is being repurposed beyond its intended scope. Now let me give you the compliance picture, because this is what matters most for the gun owner and the FFL watching this video. Virginia, SB 749 is the law. It was signed June 16, 2026. It was effective July 1st, 2026. 2 state court injunctions exist, covering Virginia State Police and 6 specific localities in Lancaster County and Washington County. Those injunctions do not apply statewide. The DOJ lawsuit in the Eastern District of Virginia seeks a permanent statewide federal injunction, but that injunction has not been entered. No federal court has ordered Virginia to stop enforcing SB 749 as of this video. What that means for Virginia FFLs, you are operating without a statewide injunction. The partial state court injunctions offer no protection to an FFL outside the covered localities. If you are an FFL in Virginia and you sell a covered firearm under SB 749 in a locality not covered by the existing injunctions, you are potentially exposed to a Class 1 misdemeanor charge and the 3-year firearm prohibition that attaches to conviction. Do not act on the assumption that the DOJ lawsuit protects you. It does not yet. Consult a licensed attorney in Virginia before making any transaction that SB 749 would cover. The grandfathering provision is intact. If you own a covered firearm that you acquired before July 1st, 2026, your possession is not affected by SB 749. The ban is on commercial transactions, sales, purchases, imports, manufacture, and transfers, not on possession of previously owned firearms. The magazine restriction under SB 749 is also in effect. Sale of magazines holding more than 15 rounds is prohibited under the law. That restriction is separate from the assault firearm ban and has its own enforcement consequences. California. Assembly Bill 1127 is in effect as of July 1st, 2026. No court has issued an injunction blocking it. California licensed dealers cannot sell, offer for sale, transfer, or deliver semi-automatic pistols with a cruciform trigger bar to buyers in California. The ban applies to dealer transactions. Private party transfers conducted through an FFL are exempt. Possession of existing Glock-style pistols acquired before January 1st, 2026 is not affected. The California handgun roster remains in effect. Roster compliance requirements are unchanged. The DOJ lawsuit challenges the roster's constitutionality, but until a court issues an order affecting the roster, all existing requirements remain fully in force. No court has entered any order affecting the roster as a result of the DOJ litigation. Colorado. The DOJ sued Colorado over its magazine ban on May 6, 2026. Colorado's 15-round magazine limit remains in effect. No injunction has been entered. Washington, D.C. The DOJ filed an amended complaint on May 14, 2026, challenging D.C.'s AR-15 ban and suppressor ban. Both bans remain in effect. No injunction has been entered. The pattern across every one of these cases is identical. The DOJ files, the state keeps enforcing, and the litigation proceeds toward a ruling on injunctive relief. Do not assume a DOJ lawsuit changes your compliance obligations. A lawsuit is a legal proceeding. A court order is what changes the law you have to follow. Until a court order exists in your jurisdiction, the statute in your state is fully enforceable. Let me close with where this litigation is actually going, because the Virginia and California lawsuits do not resolve themselves in isolation. They resolve themselves through the Supreme Court. The Eastern District of Virginia is bound by Fourth Circuit precedent under Bianchi v. Brown, the en banc decision that upheld Maryland's assault weapons ban in 2024. A district court in the Fourth Circuit cannot strike down SB 749 on its own. The realistic path to victory in the Virginia case runs through Viramontes v. Cook County, the AR-15 case where the Supreme Court granted cert on June 30, 2026, one day before the DOJ filed its Virginia lawsuit. Arguments are expected fall 2026. A decision is expected by June 2027. If the Supreme Court rules in Viramontes that the Second and 14th Amendments protect the right to possess AR-15 platform and similar semi-automatic rifles in common use, Bianchi is effectively overruled. United States versus Virginia wins. Every assault weapons ban in the Fourth Circuit faces immediate extinction, and every other assault weapons ban in every other circuit faces a ruling that gives them no historical tradition to stand on. If the Supreme Court upholds assault weapons bans, or issues a narrow ruling that leaves meaningful room for state-level restrictions, United States versus Virginia likely fails regardless of the DOJ's involvement. The civil rights mechanism of Section 12,601 cannot save a substantive Second Amendment argument that the Supreme Court has already rejected. For the California Glock ban, the Viramontes ruling will not directly control, because Viramontes is about semi-automatic rifles, not handguns. The Glock ban challenge is a handgun question, and the handgun question runs directly into Heller's most explicit language. The Supreme Court in 2008 held that the Second Amendment's protection is at its strongest when it comes to handguns, because the handgun is the quintessential self-defense weapon. California is arguing that Glock-style pistols, the most popular handgun in the country, can be banned from commercial sale because criminals have used illegal aftermarket devices to convert them. That argument asks a court to accept that the illegality of third-party criminal modifications to a legal firearm removes the legal firearm itself from constitutional protection. That is a significantly harder argument to win in court than the assault weapons ban argument, and it is the one California will have to defend. The handgun roster challenge is stronger still. A decade without new handguns added to the approved list, the result of requirements that no manufacturer can or will meet, is not a gun safety regulation. It is an attrition strategy. And Heller said handgun bans are off the table. 7 lawsuits, a legal tool never before used for this purpose. A Supreme Court case that could resolve the central question in most of them by June 2027. And a civil rights division that has stated publicly it is still looking for more targets. For the first time in the 30-year history of 34 U.S.C. Section 12,601, a statute born out of Rodney King, built to combat police brutality, and used for decades to reform departments accused of racial discrimination and excessive force, the federal government is using it to enforce the Second Amendment. Whether courts accept that application of the statute or reject it as an overreach beyond the law's intended scope is the legal question that will define the reach of this enforcement campaign. The answer is coming, in the Eastern District of Virginia, in the Central District of California, in the District of Colorado, and ultimately in the Supreme Court of the United States.